The topic with which I am about to say something is with regard to implementation of sections 5 and 6 of the Companies Act 2017, issues and challenges. First of all, I would like to thank Honorable Justice Iftikhar Mohammad Chaudhry Sahab, former Chief Justice of Pakistan, for pointing out some points with regard to section 5 and 6, and I'll be highlighting those points as well. The traces of early cooperative trading undertakings were found in 13th century, but the formal guilds were found from 16th century. A company is a union denoting association of individuals in pursuit of a common object to carry on business for gains. The company is an artificial juridical person which may own property, enter into contract, sue or be sued, do other functions as may be prescribed under the law. It is separate and distinct from its members. There could be a number of companies like joint stock companies, chartered companies, companies limited by liabilities, common law companies as defined under the law. There could also be unlimited subsidiary companies, mudaba companies, and other specialized companies called non-banking finance companies. The first proper act in this regard was Joint Stock Companies Act 1860, replaced by Companies Act 1866, repealed by Companies Act 1882, followed by Company Act 1900, amended by the Act of 1910, and finally Companies Act 1913. After Pakistan coming into existence, the Companies Act 1913, which was amended in 1929 and 1931, was adopted, which remained in vogue up till 1984, when Companies Ordinance 1984 was promulgated. This said law remained in field up to 2017, when Companies Act 2017 was introduced. As per Section 13 of the Companies Act 1913, special jurisdiction was assigned to the High Court, having jurisdiction in the places to deal with the company matters. The purpose behind assigning of the jurisdiction to the High Court was to preclude the parties not to go to the civil courts having general jurisdiction, but to approach the High Court by way of special jurisdiction. It has been held by the Supreme Court of Pakistan in the case of Mia Javed Amir versus United Foam Industries, 2016 SCMR page 213, that civil courts would not be appropriate forum for resolving such matters. The said remedy was a special remedy. Though there are certain decisions given by the Supreme Court, superior courts, that a writ is maintainable where the matter pertains to fundamental rights of a person. However, there are certain exceptions to this rule also. In Companies Act 2017, the lawmakers have introduced an altogether new provision of the law, thereby ousting the jurisdiction of civil courts in respect of the company matters. High courts would not interfere with respect to internal arrangements of a company, which are considered as indoor managements, which the company is required to deal internally and not to bring these to the courts. Indoor management matters, therefore, are neither amenable to writ jurisdiction nor through a civil court. Through Section 7 of the ordinance, the scope of the jurisdiction of the High Court was enlarged, and the matters which cannot be dealt with SCCP were made amenable to the High Courts. It would not be out of place to mention that the jurisdiction of the High Courts in dealing with such like cases is always considered to be its ordinary original jurisdiction. Any order passed by a court by a company judge is challengeable before the Honorable Supreme Court within 60 days' time. However, no appeal lies against interlocutory orders passed by a company judge of the High Court. The proceedings before the High Court are considered to be the matters of first instance, and all the characteristics and attributes of original jurisdiction, as mentioned earlier, are available to the High Court while dealing with these matters, as conferred by Civil Procedure Code 1908. Matters have to be decided after following the summary procedure as laid down under the law. Reference in this regard may be made to the decision given by the Honorable Supreme Court of Pakistan in the case of Brother Steel Mills and others versus Mia Ilyas Mehraj and others, 1996 PLD, Supreme Court, page 543. For the purposes of dealing with the company matters, each High Court was assigned with the responsibility to constitute one or more benches, known as company benches, which are to be constituted by the Chief Justice of the respective High Court. Time limit was also fixed for expeditious disposal, and it was provided in the law that not later than 120 days from the date of the presentation of the petition or an application, the same would be disposed of. The lawmakers have made the matters which are to be dealt with the company judge summary in nature, which provision did not exist in Company Act 1913. The intention of the lawmakers appears to provide expeditious and summary disposal of the matters pertaining to companies. Rule 3 of the Companies Code Rules 1997 specifically provides that, I quote, "Nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the court to give such directions or pass such order as may be necessary for the ends of the justice or to prevent abuse of the process of the court," unquote. Section 5 of the Companies Act 2017 deals with the jurisdiction of the court and creation of benches, which has simplified and reinforced that no civil court or any other court shall have jurisdiction to entertain any suit of proceedings in respect of any matter which the High Court is empowered to determine by or under this Act. Through Companies Act 2017, a new provision has been added to create Office of the Registrar of the Company Bench in each High Court. The new provision relating to registrar is mentioned under subsection 5 of section 5, which categorically provides that there shall be a registrar known as Registrar of the Company Bench, who will be notified by the Chief Justice of the respective High Court and who would be assisted by such officers as may be assigned by the Chief Justice of the respective High Court. Subsection 6 of section 6 prescribes that the said registrar shall perform all the functions assigned to it under the Act. Subsection 7 of section 5 stipulates that the Chief Justice of the respective High Court, if deemed appropriate, may also establish a secretariat in each company bench of the respective High Court in such form or manner to provide secretarial support and to perform such functions as may be prescribed under section 423 of the said Act. These three provisions of the law do not find mention in either Companies Act 1913 or Companies Ordinance 1984. Through this subsection, a post of registrar has been created, who is to be appointed by the Chief Justice of the respective High Court, and the job of the said registrar is to assist the company bench by presenting a case file to the court on a date fixed under notice to the parties. The registrar is saddled with the responsibility to perform all such functions as assigned to him under the Act, which, as stated above, will include all ministerial and administrative business. He will receive the petitions, applications, written replies, and issue notices to the respective parties, which includes service of summons and other functions as prescribed under section 423 of the Act. The format of a petition or an application has also been prescribed under subsection 2 of section 6 of the Act, according to which a petition or application setting out a concise statement of facts, grounds, and the relief claimed is to be filed along with an affidavit. Upon receiving of the petition or application, the registrar then serve a notice upon the respondent through the manner prescribed under CPC or through electronic mode as the case may be. The respondent would then file a written reply within 30 days of the receipt of the first service, and in case the respondent fails to file the written reply within the prescribed time under section 4 of section 6, the matter would be reported by the registrar to the company bench, who may pass necessary orders as deemed necessary by the said bench. In case of receipt of reply from the respondent, the registrar would ensure that all written submissions as furnished by the parties are presented to him. He shall then prepare a case file and then present the same to the court, who will fix a date for hearing of the case. It has categorically been provided under section 8 that no adjournment shall be granted once court starts hearing the matter, and only in exceptional circumstances the hearing would be adjourned, however subject to the payment of cost at the rate of rupees 10,000 or such higher amount as determined by the court. It is provided under section 9 that affidavit, counter affidavit, and documents filed by the parties will be placed before the court, and the court would proceed in a summary manner and pass the final order within a period of 120 days from the date of the presentation of the case. It is also provided under subsection 10 of section 6 that only in exceptional circumstances cross-examination would be allowed to the parties. The court is also empowered to refer the matter to the registrar of the company bench for recording of cross-examination within 30 days from the date of the order of the court, or such extended time as may be granted by the court. The power of the registrar of the company bench insofar as recording cross-examination and summoning of parties are concerned are to be governed through CPC. Subsection 6 of section 5 provides establishment of a secretariat in each company bench of the respective high courts in such form and manner as may be prescribed under section 423 of the Act. Section 423 of the Act provides power to make rules in this regard, and the Supreme Court may, in consultation with the court or upon the advice of federal government, would proceed accordingly. It would not be out of place to mention that no such rules, so far as my little knowledge is concerned, have been framed so far. It would also be not out of place to mention that section 6 starts with non-obstante clause ousting the jurisdiction of all other civil courts in respect of the company matters, and after the appointment of the registrar of the company bench, all the company matters which include filing of petitions or applications, etc., have to be dealt with by the said registrar, who would lessen the burden upon the company bench and would save time in fulfilling the legal formalities of summoning the parties, and through the registrar they will receive a complete case file and would then proceed to decide the matter between the parties finally in a summary manner. A perusal of the above provisions of law categorically reveals the importance of the post of the registrar, as he would be the person who will prepare the case file and present the same to the bench when all due formalities as prescribed under section 6 are fulfilled. Hence, in my view, this post has to be filled with a suitable candidate, not only having sound knowledge of company law, but he should also be well versed with other civil laws, including CPC. I therefore would suggest that the Chief Justices of the respective High Courts to kindly appoint the registrar of the company bench, if not so appointed so far, as early as possible, for doing the needful in accordance with the law. I am really grateful to the chairman and the Prosecutor General of SCCP for inviting me in this symposium and providing me the opportunity to present my paper on this topic. I am also grateful to Mr. Ziaul Rashid Abbasi, an officer of the SCCP, for his assistance. Thank you very much. Pakistan, Pindabad.